Fourth, and should be final committee meeting on service delivery strategy. And Chairman Ginn and I have been communicating a lot with some of you and the two associations, ACCG and GMA, and hope we can have some good discussion today and make great strides towards wrapping this up. So I want to thank those committee members who have chimed in with recommendations or responses to the draft recommendations. It's very helpful to keep the conversation going. Before we go any further, I would like to ask someone to open up in prayer, and Chairman Prince is going to do that for us.
Let us pray. Eternal God, our Father, we thank you for this day. We thank you for another opportunity to come together and do the business of this great state of Georgia. Father, we ask that everything we do here be pleasing unto you. Guide us, strengthen us, give us your wisdom, guidance, but most of all, thank you for your Son. In Jesus' name, amen.
Thank you, Chairman Prince. All right, so we will call the meeting to order. You've all seen the draft recommendations, which I will get in front of me. And Mayor Ward has sent us all his responses to those, his recommendations, and Commissioner Chris Dockery has done the same as early as recent as this morning. So what I'd like to do is just hear from the committee members your thoughts on these recommendations, and then I've had some conversations offline with Chairman Ginn, and we both talked with ACCG and GMA, and what we'd really like to see here, because I've been in the legislature since 2018, and this issue predates that by a few years.
A few decades.
Yeah. But the way I understand it, this issue's been, there's been talks to resolve some of these differences, the dispute resolutions, for at least 15 years. And here we are still talking about it, and we've had this study committee that GMA and ACCG and others have asked for, and we're still not quite there with a joint agreement. Or list of recommendations that both parties are agreeing, to be the solution to this dispute resolution. So what I'd like to do is just talk through these comments, and then ask the two associations to get together in short order and get back with Chairman Ginn and I on those points you can agree on. And I hope there's only just a small number that you say you can't agree on, but we need something that we can go into session with, or else this is going to continue. And then we'll look back 15 years from now, and we might still be having the same conversation. So, Chairman Prince.
Thank you, Mr. Chairman. And again, I'm looking at the recommendations, and I think they're spot on. However, I know ACCG and GMA had policy meetings or something else going on around the same time. Will they have time? Because I think, I guess I'm asking a question. Don't we have to have a report or something back to the Lieutenant Governor and the Speaker here by the end of the year?
We do. The initial deadline was December 1st, which is passed, and we asked for an extension, and they gave us an extension to December 31st. So thank you for clarifying that. So we do have till December 31st. However, we don't want to wait till the 11th hour of this extension. And I'll ask Chairman Ginn to weigh in too, but I think, we have holidays coming up. Today is Today the 4th. That's right. Santa's on his way. And so, first of all, this meeting today, we've agreed needs to wrap up within an hour, and then we'd like the two associations to come back to us with your approved recommendations, and plenty of time for us to get together on a report before the end of the year. So I'd say before Christmas. Do we want to set a hard date to meet with them?
Yes. The,
We got a question from Chairman Burns.
Thank you, Mr. Chairman. As we look at these recommendations, there are, I guess, 6. Is that right? Is there consensus on any of the 6? Is there a consensus that we could say we can settle those and leave the 2 or 3 that might still need more consideration? I'd love to get to closure on something.
I would like to hear the answer to that from the parties.
All right,
You know,
and
if
then
there's consensus to both.
I would, if I may, Mr. Chairman, I'd like to suggest that ACCG and GMA address all of the 6 recommendations and just say, we're good with this. We'd like to consider this further. That's what that's what I'd like to hear. I don't see a great deal of contentious debate about statewide mapping standards for SDS agreements. They may be, but I would say I don't anticipate that.
So, thank you, Chairman Burns. What I'd like to do is hear from the 2 parties, but also I'd like Commissioner Dockery and Mayor Ward to be able to summarize their recommendations for us while we're all here together. So, looks like Commissioner Dockery might be ready to do that now.
Mr. Chairman, I would just suggest that we as a committee, since that's our charge to come up with this report, that we go through it and come up with what we think is right. And then if there are outstanding issues that we as a committee can't iron out, then we give ACCG and GMA time to look at those issues or help us to address those issues as to what a compromise could be. And then, of course, I can't speak for GMA, but ACCG, we would want to go back and vet that through our policy council. And we could do that. We could do that via Zoom in short order. So I don't think that's an issue. But I would suggest that we as a committee go through each one of these bullet points and discuss them as a committee. And then if there are outstanding issues, maybe ACCG and GMA here with us today could help us get through those. Just a recommendation.
Yes, I'm in favor of doing just that, but I'm not in favor of finalizing the report without
Correct.
ACCG and GMA saying we agree with this or we don't agree with it officially. That's what I want. I want some finality to the report from each association. So, would you like to go first and summarize your recommendations that you sent out to us?
I'll be glad to. Do we just want to go over the first bullet point, which is statewide mapping? I can tell my position, and then if anybody on the board or on the committee wants to give theirs and just do them one at a time?
Yeah, that works for me.
What's your say, Mr. Chairman? Okay, so the statewide mapping, I do think that that's good. It adds a lot of standardization. And in my comments, one of the biggest concerns I had is forcing communities to identify 100% of their areas as for service delivery. In other words, there may be some areas that are not designated, and a community may desire to leave that undesignated, not knowing what the future development may be. Because if you designate it a certain way and then the development comes in and it's completely different from what you anticipated, then whoever's designated to provide that service might not be able to. So I'm not sure that there's a benefit to making sure 100% of the land areas would be designated. By doing so, I think what you're doing is you're forcing communities to do a pencil drill where we say, well, we'll just do this and you do that without any thought behind it. And then when it comes down to it, it might not be the right answer. And it could be very contentious in doing so. One thing that has to be considered is the ability of certain communities to do the GIS mapping. So, that might be a fallback to regional commissions to help with those things, because I'm not so sure that every municipality in every county in the state of Georgia has that same capability for GIS mapping. And then we talked about the DCA rulemaking authority, and I think that's a bullet point on down, but I think it's applicable here because this is a very specific issue that I think that rulemaking authority could be a big benefit, because as technology changes, maybe the requirements for those maps would change as well. So I don't think that's something that has to come back to a legislative body to update. So that would be, in my mind, a good place for DCA to have that rulemaking authority to change what that requirement would be. And it would be equal across the board for all communities. So those were my big comments on the statewide mapping standards, Mr. Chairman.
All right, so just for my clarification, the rulemaking authority to DCH, I believe that's what some believe is giving too much of the legislature's role away to not DCA, excuse me, DCA. Is that, am I right on that?
Mr. Chairman, if I may, I think if you just give a blank check, so to speak, to DCA, you're putting them in a very uncomfortable position, because I think that is the job of the legislatures. But if it's something as simple as what's required as far as mapping, a very specific rulemaking function, then I think that that would be acceptable. It certainly would in my eyes, because it allows them to adjust maybe as technology changes. But to come up with rulemaking authority as far as how you're going to have dispute resolution, I don't think that DC, that they're going to do, I'm sure, what you tell them to do, but I don't think that puts them in a very comfortable position to pick winners and losers, or to come up with a process that favors one government entity over another. So the rulemaking, just as a blank check, I'm opposed to. But if it's a specific specific issue that can be defined, I think there's a place for it.
All right, thank you. And that's your position on bullet point, the first bullet point. Mayor Ward, would you like to speak to that one?
Sure.
All right, what number are you? 13. All right, go ahead.
Thank you. So I think the low-hanging fruit on this is the statewide mapping. When I think policy, a lot of the role we play on the mayor level is to set policy as opposed to set procedure, if you will. So the why and the how is what we, the why and the what is a lot of what we answer. The how, we try to maybe leave that up to our staff a little more. So that's more along the lines of what I was thinking in this. But if we just look at Chairman Dockery's report and kind of eliminate mine for a minute, or his input, I don't believe that under the first bullet point, his subheading number 1, I don't think that the GMA position will differ greatly, that there could be territories that are left unestablished, if you will, because then it wouldn't necessarily be well, you have to take it from me later. If it's unestablished for now, it could be unestablished on an ongoing portion. And I think in support of that, if you were to look at the proposed recommendation on my report on page 1, that's why we kind of indicated there, including data and parcel jurisdiction level. So then we really lay this thing out and we know what the data and parcel jurisdiction levels are. With regard to the DCA rulemaking authority, I don't know that we drilled down that close. We did recognize that the Georgia Geospatial Information Office has on its board members of GMA and members of ACCG. And more so leaned in the direction of saying, hey, these are mapping services that both of these entities have a part in, and let that mapping service play more of a role. So to keep my comments brief and to help us get through this, I think that's about where I wanted to start.
Okay, thanks. Chairman Ginn?
And I think they're both hitting on the same thing for me. When I talk about, in my mind, DCA's rulemaking, this is what you've got to have in your maps. This is what you've got to do. And I think that DCA can work with us as local governments to make sure that, across the state, there is uniformity in those maps, and I think those rules can come from DCA. I don't think that's something that we need to legislate in, but I do think that when I look at and truly the first attempt in Georgia that I know anything about on service delivery was maps that were created for the Electric Territorial Service Act of 1973, where you identified all areas of the state for who's going to serve with what area. There are a few places in that map that show that there are some undetermined areas of the state, but very few. And so for me, when I think about most counties, yeah, there be some counties I think about the Okefenokee Swamp or something like that. That hey, it might not be one of those places we'd put in the map as far as who's going to service delivery in there, but very, very few. I think it'd be the exception to the rule, and I'd like to see that and when the maps are done, as much as possible would be there. I think it would, because then you're either on this team or that team as far as who's going to serve it. And then I think, and I give my local officials a lot of credit that they can work amongst themselves to, okay, it's ours now. Either you're going to serve it or tell me that you can't. If you can't serve it, then the other service providers would come in and serve it. But I think it's by having it known when you agree to a service delivery map that it is in A or B or C or D or any of the providers that may be in that community, by it being assigned to at least one of them, if they can't provide it, then somebody else can step up to the plate and make that recommendation. And for me, I think that's a prime example of where we'd use DCA's rulemaking ability to hey, here's what your map's got to be like, here's the format, here's what you got to do.
Thank you, Chairman Gann. Any more discussion on the first bullet, on the maps? That one seems pretty agreeable. All right, second bullet point. Mayor Ward, you want to go first on that one and explain your recommendation? I think you agreed on it.
I appreciate you giving me the easiest one on the board. Yes, I think the consolidated governments can make their own rules and get along with themselves much easier than cities and counties that are not consolidated.
All right, and Commissioner Dockery?
And Mr. Chairman, I didn't have any comments on that one either.
Okay.
That's kind of a no-brainer.
Yeah, and I don't mean to skip over anybody else if you've got anything to weigh in, so that one seems pretty simple as well. All right, how about the third bullet point? Who wants to start? Anybody have any comments on reconsidering the issue of veto power? I think that's the not so easy one.
I had a lengthy response on that one. If you prefer, I start.
If you want to summarize your thoughts,
Sure.
Go ahead.
I think in conjunction with the staff, we tried really hard to modify this one to where it was hopefully a simple recommendation that could be adopted, that was broad enough it could be adopted. With regard to the veto power, we feel like primarily the thing to look at is the consideration of a holdout city was addressed in the current legislation. And I think I've cited the statute there. I don't want to try and recite those off the top of my head. But we definitely can understand the discrepancy that a small city trying to take captive everyone else could be an issue. But there is already a statute that says if it's a small city, well, they are still able to hold out. They're not forced to provide the service, but that doesn't cause penalties against the county or the other cities that bought in. We see a lot of wise decision making and how that's already drafted, and don't see the reason to alter that. With regard to coming to an agreement, we also see some wisdom in the required signatories as they're currently drafted. It's literally, if you look at the statute, I mean, it's just a chart of 1, 2, 3, 4. These folks can rattle that off the top of their head. I'm not that eloquent, but we don't see a lot of reason to alter that format either with regard to establishing a new veto power versus what's the current signature perspective. I think that's a good high level for where we are at the moment.
So, if I'm right, you would prefer just to remove that recommendation from the list?
That's right.
Yeah.
That's right. We just think that the current plan with regard to preserving any chance of the county getting harmed by a small city being a holdout has already been dealt with, and we think the current plan of required signatures under this 4-level process, we think that's appropriate. We don't see a reason to try and modify those.
Okay. All right. Anybody want to respond with thoughts? Do you have thoughts on this one, Commissioner Dockery?
Yeah, Mr. Chairman, if I may, Mayor, you said there was a process in place by which a smaller city could not hold all the other parties hostage. Can somebody smarter than me explain what that process would be? Does it go based on population? How does that?
County seat. Larry, I don't know if you want to address it, but for me, a good example would be, I'll pick on Franklin County where I was county manager. The county seat was one of the smaller counties, smaller cities population-wise in the city as far as the county. And if you don't have that signature from the county seat, you basically can hold the agreement up, is my understanding.
I think that's right, Mr. Chairman. Larry Ramsey with ACCG. So the existing law that Mayor Ward is talking about lists what local governments have to sign off for a service delivery strategy to be submitted to DCA. That's the county, the city that serves as the county seat, as Chairman Ginn was saying, any other city that has at least 9,000 population, then at least half of the cities that are within between 500 people and 9,000 people. So in effect, what that means, if you have a city that's less than 500 people, they don't get a vote. They can't hold it up. And then some number, if you have multiple cities between 500 and 9,000, only half of them have to sign off. So there could be some that or don't have a vote that could hold it up in that category. But of course, that will vary county by county depending on what the city makeup is.
All right, Mayor Ward.
On page 2 of 5 in the report I put together, the last sentence of the second to last paragraph, OCGA 367027B1. What I did and when I got y'all's report is I reread the entire act just to try and make sure I was fresh on what we were thinking and where it could apply. And that's where this one already does mitigate against sanctions against the county and any other municipality located in such county in circumstances of a holdup by a city of less than 500 people. We felt like that's a good statute there.
Mr. Chairman, if I may, when this was brought up in Brazelton, I can't remember who brought this issue up, but I was thinking that it might have been somebody representing a municipality that brought this up. I don't have strong feelings one way or another because I think it could affect municipalities equally as counties. And if it's something that is not that important or beneficial to include, then I'm okay with it, taking it out.
So the idea is on the table to remove it. Is this, what does the committee think about, part of the purpose here is to put some processes in place that encourage dispute resolution. Is taking this out going to soften that, or is it going to be another barrier to coming to a resolution, to encourage these disagreements to linger?
With respect to the GMA side of this, I feel like what we're also looking to incorporate is going to be maybe more effective and more appropriate. I do think the encouragement towards sanctions and the encouragements towards better procedures for sanctions. So maybe we don't make a decision on this third bullet point at the moment, but we wait to see how we discuss the others and feel if those would be the right process, and we can come back to it if we need to.
Yeah, I do believe that the fifth bullet point about the sanctions may.
It's going to gravitate this.
That's right.
Yes, sir.
So, all right. So we'll move on to the fourth bullet point, which states further consideration of use of arbitration versus mediation in the case of disputes and whether both or neither should be binding. Any comments there?
I think Chair Dockery should lead on this. I tried to lean into his comments more so in mine to make sure we felt that way.
All right, Chairman Dockery.
So I think it all goes back to home rule. You know, I was involved in loss negotiations and baseball arbitration, and we all know what the court ruled as it related to the baseball arbitration. I'm not sure that you can have binding mediation. I'm not sure what that looks like. I think mediation should be encouraged as a first step. And then I think arbitration's a good method of resolution as long as both parties agree to go into arbitration. So, you know, if you just establish the recommended process, I think that's what should be done. I'm not so sure that the binding should be included. You know, again, I think it all goes back to home rule, and I can't remember who said it in Brazelton, but you know, your local officials are elected to do these things, and when you take a decision out of the hands of the local officials and you put it into some special panel that's made up of people outside your community, I'm not so sure that that's what our constituents are expecting us to do. So I'm not in favor of that panel or any binding arbitration. I think arbitration should be encouraged, mediation and then arbitration, but I'm not in favor of any binding arbitration by an independent third party that's appointed by somebody other than the people that should be held accountable in those communities.
Go ahead.
If I may,
Mayor.
Mr. Chair, I think we actually have some common ground here. As a person who deals with, there's a bunch of words here. Let's get the word salad correctly, if we will. Alternative dispute resolution, or ADR, kind of begins on the spectrum of mediation, and then it goes up to arbitration, and then it would go to binding arbitration. That's kind of the 3-layer spectrum, if you will, of alternative dispute resolution. I think the current statute incorporates mediation as a mandatory role, and I think the consequence of that mediation has not been harsh enough, if we're going to get into the consequences discussion.
And is that where you believe the next bullet point would address?
Well, I think in this article, this number 4 bullet point is going to lend itself. What I personally see is that we can use this role of what Chairman Dockery just said was, hey, not binding arbitration, but arbitration. I think that's a common ground we could look at, and that's a ratcheting up of consequences to just help further that beginning illustration and hopefully not to go too long. Mediation, I have failed mediations, right? I sit down with my clients. They're not going to come to a resolution. They're not going to settle the case for less than what they want. So the whole process is a failure. It's all under a confidentiality perspective, and you walk away. And arbitration is where a neutral third party is going to actually issue a decision, and that decision could be made public. And that's where maybe it's not binding on the parties, but we think that could be another layer of accountability and consequence if we want to look at arbitration versus just the mediation angle that's currently in the statute. Does that make sense to you on how I see that as a consequence?
I think so, yep.
Okay. So that's where the 2 roles of this that we feel like on the GMA side that I believe we've talked about. I'm not looking at my colleagues enough to get nodding heads. I should probably do that. There's a lot of heads over there. I'm not sure if they're all looking down or looking at me.
They're looking at each other.
Yeah, like who put this guy up there, right? But I think if we were to look at arbitration to make a recommendation to increase the ADR option from mediation to arbitration, and then to also consider this closed record discussion that was mutually, I think, offered by the ACCG and GMA panel, and that I feel very strongly about, to say that it does expedite resolution. When you close down the number of arguments, you just think of it as a criminal prosecution, right? This is the one that's the easiest for everybody to understand. If you're accused of a crime, the prosecution's got to tell you everything that they're going to charge you with and all the evidence they have. And you know what that does? That gets 99% of cases settled that people take a plea agreement, because everybody understands what's going to be on the table and what's going to be dealt with in front of the judge and what the arguments are going to be. And then they cop a plea deal or they go and fight it, right? but you see the percentages from my colleagues that are in the prosecution side. So I really feel like the closed record component, I would again encourage that, and encourage it along the arbitration level, maybe more so than the mediation level.
All right, so, and I know you're, more aligned with GMA and Chairman Dockery more aligned with ACCG, although not necessarily speaking officially for either one, and that's why I'd love, at the proper time for both associations to let us know what they
Condone.
what their official position is on this. And Commissioner, do you have anything to add to Mayor
No,
Ward's comments?
I think like Mayor Ward said, there's some common ground there. And if you go to the next bullet point 5, if there's consequences for not reaching an agreement, that goes right in line. I'm just not so sure that binding is the last and final step. So, I mean, if you have mediation and arbitration, I do like the idea of disclosing your arguments, your closed record, as you call it, disclosing everything that you're going to present, so that you don't have new things popping up. That I've been through that. That's ugly. It kind of galvanizes both sides when you do that. So, I would be in agreement with that. It's just the whole binding part I don't think I can support.
All right, well, let's talk about that 5th bullet point, the clear definitions for sanctions, with council to review the current legal viability of withholding loss/SPLOST funds from noncompliance with SDS renewal. I know a previous version of this maybe went as far to talk about a time frame, maybe 6 month, up to a 6 month abeyance, but after that, the consequences sink in. I'd like to hear some comments on this one, because I think this is where we're actually getting into, forcing the parties to make a decision and to come to some agreement. I mean, this is when citizens will start to feel it and notice it.
Yeah, on that light, let's let Chairman Dockery speak first.
Oh, you always want me to go first. No, I agree, but I think it needs to be a timeline, and I think that vice needs to tighten. You're not going to drop a hammer to start with, so those sanctions, if you will, would be graduated. So, as you go through your mediation, your arbitration, the results of the arbitration made public, and then you start losing some of your funding or your status, your ability for funding. But then I think if that is graduated, now what that actually looks like, it's probably going to take somebody smarter than me. But there has to be consequences. At the end of the day, there has to be consequences. These things that go on for 7 years are crazy. So I think if there's consequences and it's very well laid out up front, then I think that gets the parties to the table. When you start having more to lose than you have to gain, I think if I can steal some of my lawyer talk and you go back and talk about Beccaria, the punishment has to outweigh the benefits of the crime. Is that right, Mr. Mayor? So when you go back and look at that, I think that the punishment or the consequences have to outweigh what you're gaining by holding out. That's the only way it's going to work. But it needs to be graduated. That's my thoughts.
You got agreement here, I think. The way ours is drafted, if you were to look at the statute, 3670 25.1 D2, this is discussed on page 5 of my report. But again, D2 is where the statute currently allows the court to hold that those sanctions in abeyance. And the way that I redrafted the proposed recommendation on page 2 with regard to this is just to say that further consideration on imposing sanctions at staggered levels and intervals, which I think Chairman Dockery is talking about a spectrum of how to do that.
Exactly.
The illustration I give in my discussion on this is kind of start with removing radar permits, and then as it ratchets up, and I would be extremely naive and inappropriate to say what those levels should be and what those penalties should be at what level. But I do think that's where your thought of saying, hey, ACCG, GMA, we really want a firm list on this. I think we're all in agreement as a committee that they would want to do that. And to further a comment I've said in a previous meeting, that if you say arbitration is going to take 6 months to do, well, then maybe you allow them to be held in abeyance if you're participating in arbitration for those. But after that arbitration, the consequence kicks in.
Yep. I personally like that one. I think that's
the
the
meat.
one that's going to get things moving. All right. So I think what we want to do is hear from GMA and ACCG on more specifics on the graduated sanctions. All right. The last bullet: granting rulemaking authority to DCA.
I think the
Is that a
mayor
good
should
idea
go
or not?
first.
Sure, we didn't have any strong comments about the recommendation from the board. I think the simple statement is that we would like to keep this at the legislative level while everybody's engaged as much as we can. DCA, albeit a fantastic authority that helps both the cities and counties quite a bit. But as Chairman Dockery said, giving a blank check, if you will, we just weren't ready to go.
Chairman Ginn.
Thank you. One of the things, and it's come up, and this happens in our legislative process. We have a lot of different boards and associations in the state, and DCA being one of those. If they're looking at a rule making and rule changing situation, then part of that they have to notify the legislature, and the correct committee in the legislature that rule change is subject to take place. That gives the legislature an ability to put that, if the appropriate committee objects to that, they can pull it back. So there's one of the things that there is a check and balance on that. When we give them rulemaking authority, there's still a string attached that we can reel them back in if it gets too far off note. And I think that's important to know, what we do with our different boards and authorities across the state.
So, not to put anybody on the spot too much, but with DCA in the room, is that something that you feel like, some limited rulemaking authority is something that would work for you? Yes, sir. All right. So we've gone through the 6 bullets, and looks like some are pretty easy to agree on, and others are going to need a little bit more, I think, meeting of the minds between the stakeholders. Chairman Ginn and I feel like December 15th is a reasonable time to, allow the parties to meet and get back with us on, just tell us, out of these recommendations, which ones can you agree on and which ones do you not agree on? Or what's your position on each of these? And if you want to get a little more specific in some of them, I'm okay with that too.
Mr. Chairman, can I make one last comment on number 6? And I'm just going to read my bullet point 2 verbatim, because I think the Department of Community Affairs does a great job for local governments, both municipalities and counties in the state of Georgia. But I'll just read that bullet point, and I think that sums it up. It says DCA should be a neutral state agency that's not subject to special interest or political pressure from either side. Without specifying the rulemaking authority, it will put this agency in a very precarious position of potentially being influenced by special interest organizations. This holds true when selecting panels by DCA as well. So even just those panels that DCA selects, I think it would be very naive to think that there wasn't some political posturing as to who's going to serve on those panels. So I think that, again, that needs to be very limited. And with that,
All right, Mayor Ward.
In the directive you're giving by the December 15th deadline, is that directive to say that the 2 agencies need to agree on the terminology that you all propose, or if they take the model you propose and agree on their own terminology to come back to you? Is there flexibility for them to do that?
Yeah, I don't think we want to limit any, more ideas from coming to the table. I do believe we want to use these 6 bullet points as somewhat of a framework for the discussion. But if the ideas that are discussed, expand beyond this, I'm okay with that. And I think Chairman Ginn is, we think we've narrowed it down, pretty well in these 6 bullet points. But again, if you need to massage those and or expand some, I think that's good if it brings solutions. But the main thing is, and I realize, this is going to get debated heavily during the legislative process. I just think it's helpful to have, especially since these 2 associations asked for this study committee, I just think it's appropriate that they, honor that. All of our time that we've spent, a lot of us hundreds of miles coming to these meetings, and a lot of time, and so I just think it's the thing to do to get them to state their position on these, and hopefully they can come to agreement on most. So the committee feel comfortable with that, and also don't want to diminish the voice of the committee members. The recommendations that have been brought to us, and the expertise is invaluable, and has got us to where we are now. And I just think it's that last step that we need for
What you're asking for in my role is you're wanting a consolidated pretrial order before we go into the session, right? I think that's a very fair request.
I don't know the legal term, but it
Right.
sounds
Right.
good. Yes, right. And so, if there's no other discussion from the committee, and seriously, I appreciate everybody's time and consideration. I think we've narrowed things down pretty well, and if ACCG and GMA could help us finish this, I think everybody will be grateful for that. And going into session, we'll have some good solutions to work off of. Otherwise, I think this just gamemanship just continues indefinitely. So, all right. Well, if there's no other discussion, appreciate everybody coming today, and we'll be adjourned. All right. Thank you.